Before rejecting on these grounds, it's important to understand what is this earlier trademark. An earlier trademark is any trademark which is already in the market and is being used by the proprietor, whether or not they are registered or whether it is a common law trademark, and therefore an action in case of a second mover would be an infringement in case of a registered trademark or passing off in case of a common law trademark. Does the opponent have the appropriate interest on which to base a challenge is important. And finally, has the earlier mark been used? Like I mentioned earlier, the strength or protection of a trademark is only as long as it is in use in the market. Next, let's understand likelihood of consumer confusion being the hallmark of trademark infringement. The best examples to understand is drinking water. For example, if packaged water such as Bisleri, which is wrapped with a blue label and a flapel in that sense, and another bottle with a Billuri, which is again packaged water, there can be huge confusion because of their deceptive similarity. A consumer looking to drink water may end up drinking another water thinking it to be coming from the first one. And the analogy or best commonplace example would be, say for example, your mother asks you to run an errand and buy the white detergent she uses to wash clothes. You go to the shop, you see a plethora of options which are white detergent, and you do not know which exactly is your mother's preference. So you pick up one packet under the assumption that probably your guess is right. Or you ask the seller, who then sells you to the best of his knowledge what would be your mother's preference, which is questionable then, because your consumer, that is your mother, may then feel to have failed the idea of having a preference in the product because the quality or the nature of the product cannot be judged by simple white packaging. So what trademark essentially then did was labeled it to help identify the product and the preference of your mom. The second option would be, if again you're supposed to go on to pick up say detergent X as opposed to detergent Y, which is white packaged, and by the time you actually come to the shop, you forgot whether it is X or Y. How difficult is it to change a Y to an X? And so you're confused at the store and you buy whatever is to your mind most suitable for your mother. This again might be questionable about the quality and the standard of the product that your mother would be preferring. So all of that essentially leads us to understand what really confused you. A, you are a consumer who has imperfect recollection, yes, but it is you that the market wants to serve. And essentially other examples would be, say for example, the Nike swoosh. Nike has merchandise in clothing as well, and a similar recent market sales essentially mention a second mover writing "I like" with the same sort of swoosh, then confusing the consumer whether it originates from Nike itself or not. And therefore an action for infringement, or even for that matter dilution, can be applied. Other example or a good case law to discuss at this point would be Hoffman versus Jeffrey Manners. In this case, the subject matter is essentially vitamin preparations. So Protowit was registered for one of the vitamin preparations manufactured by the appellant company in this matter, and the respondent company applied for registration of its mark Dropowit in respect of medical and pharmaceutical preparations and substances, and the application was granted. Later on, the appellant came to know about this trademark and it asked the respondent to alter it. On refusal from the respondent, the appellant went on to ask for rectification of the register and removal of the respondent's mark from the register. The question that fell for consideration before the court was whether the word Dropowit was deceptively similar to the word Protowit and thus offended the provision of section 12(1) of the Trademarks Act. And finally, secondly, whether the word Dropowit was an invented or a descriptive word for the purpose of section 9(1). The court went on to understand that Dropowit essentially would mean to have been broken out to be meaning as a vitamin supplement. However, it does not directly end up describing the product, and the court held that in order for a trademark to be found deceptively similar to another, it is not necessary that it should be intended to deceive or intended to cause confusion. It is its probable effect on the ordinary kind of customer that one has to consider. And so the word Dropowit, being an invented word as such, was entitled to be registered as a trademark, and the appeal was held in favor of the respondents. The other way of understanding relative grounds is the trademark shall not be registered if its use in India is liable to be prevented by the virtue of any law. By any law, furthermore, it actually mentions the law of passing off. that is protecting an unregistered trademark in the course of trade and by virtue of the law of copyright. To be noted here though is the consent of the proprietor of the earlier trademark to the second mover can then validate the registration of the second mover. Essentially, clause 4 of section 11 says, nothing in this section shall prevent the registration of a trademark where the proprietor of the earlier trademark or other earlier right consents to the registration, and in such case the registrar may register the mark under special circumstances under section 12. So when can a trademark not be refused registration? It is to be noted when the consent of the proprietor of the earlier trademark is given, and unless objection to any one or more of those grounds is raised in the opposition proceedings by the proprietor of an earlier trademark, the trademark may not be refused registration. Furthermore, a well-known trademark is required to be protected under the law, because a well-known trademark as such is a mark which has acquired its distinctiveness in the minds of the public and is already as a first mover in the market. So while considering an application for registration of a trademark, an opposition filed in respect of such a well-known trademark, the registrar then shall protect a well-known trademark against identical or similar trademarks. That means the second mover to the well-known trademark will not be allowed because of relative grounds of similarity. The next is how to assess this relative ground of deceptive similarity. It would actually go on to be a comparative analysis done by the court to assess the extent of similarity in that sense. Where a trademark has been registered in good faith, disclosing the material information to the registrar of where right to a trademark has been acquired through use in good faith before the commencement of this Act of 99, then nothing in this Act shall prejudice the validity of the mark or the registration of such a mark or the right to use that trademark on the ground that such trademark is identical with or similar to a well-known trademark. So in a sense, we have covered a plethora of issues here. We started by understanding the term of the trademark, the importance of registrability, then the grounds for refusal, as well as the absolute and related grounds that the court applies to accord a grant of registration for a trademark. Let us go on to summarize what we've learned so far. Section 9 of Trademarks Act has listed absolute grounds for refusal of trademarks. So we began by understanding what essentially means to be the intrinsic quality of a mark, and these intrinsic qualities directly relate us to distinctiveness. So mark should not be registered if it is not of a distinctive character. And we went on to understand, by virtue of an American case law, the spectrum of distinctiveness on a level of marks which are described as being fanciful, which is an invented word, not available to the public before such word was invented. Example that was discussed was Kodak. Next was arbitrary, where a separate word was attached to a new good or service to attach and bring out a new meaning. The example we discussed was Apple computers.